I'll lead you into those.
Okay.
Okay.
Can I add to the previous answer?
Oh yeah.
Okay.
I'm sorry. I'm sorry.
So,
I'm
well,
sorry.
I just was thinking that I would say another common misconception that people have when they're just starting out with an Atkins case or a potential Atkins case is because you have to have an IQ score to meet the diagnostic criteria. It is very tempting for defense teams to start with an IQ test. And I understand why people go that route because you have to meet that criteria, and that seems like an easy way to find out whether you do or don't have a claim of intellectual disability. But that's another common thing that I would say sort of right off the bat is that you don't want to just go in and do an IQ test, because whether you need an IQ test or not isn't really knowable until you've done an exhaustive investigation. And which experts and what testing might be appropriate for each case can vary, and you can't really know those things either until you've done the investigation.
That's interesting, because I would have just naturally thought that, hey.
Well, I think it makes sense to people, right? You got to have an IQ score, so why not just send someone in to get an IQ test and have that be the first step of your investigation? But you really can you can generate bad evidence sometimes if you do that, and you may also not even need an IQ test. You may find when you do the investigation your client already has IQ scores that are going to inform you about his level of functioning.
Okay. So let's talk about why it is challenging for some attorneys to identify mild intellectual disability. What are some of your thoughts on that?
Well, I would say it's challenging for anyone to identify mild intellectual disability. It's not just attorneys, but it's anyone, even experienced experts in intellectual disability. They can't identify whether someone has or doesn't have intellectual disability just from talking to the person or from learning about their background, because there isn't any one piece of evidence that rules intellectual disability in or out. It's really a product of the overall consensus of the information. And so the only way to know is to collect everything you can possibly find about a person's life history, their level of functioning over time in lots of different areas of their life, domains of their behavior, and that sort of thing. And then you sort of put it all together at the end. And that's the only way anyone can tell if someone has intellectual disability, certainly in the mild category, which is what we're dealing with.
Yeah, I've kind of, reading a little bit about it and this whole investigation, it seems like it's almost as deep as, my background is military, and you have like different security clearances. So it seems like you have to do somewhat the same thing as far as delving deep into that person's life and talking to a lot of people and things of that nature. So what is the issue with relying on perceived adaptive strengths? I mean, we talked with John earlier, and he said we really should be looking at the weaknesses, but he touched on this thing where people look at the strengths of a person. I think he mentioned the Brasileño factors that Texas put forth, where it kind of really focused on the strengths. What is the danger in that? I mean, talk to us a little bit about that.
Well, the diagnostic criteria are about deficits. So to meet the criteria for deficits in adaptive behavior, we call it, you have to have some deficits. But whether you do or don't have strengths isn't part of the clinical analysis. And I think in part because everyone has strengths, right? You have strengths and I have strengths. And so what we're interested in on that issue, prong 2, we call it, which is deficits in adaptive behavior, is what is a person's typical day-to-day functioning in an ordinary community setting? And what matters in terms of determining whether someone meets the diagnostic criteria for intellectual disability is, do they have deficits in some areas in such a way that they either can't do certain things or can only do those things with more support than we would expect non-intellectually disabled people to need in order to meet that same level of functioning, if that makes sense.
Yeah, yeah. I don't know why you say I don't do cameras. I mean, you're doing phenomenal. I'm just like, can you talk to us about the influence of a person's culture, ethnicity, language plays a factor in how one would try to help defend someone with ID. I mean, how does that all work? What are we talking about here?
Well, there are a whole lot of issues about culture. You are supposed to consider a person's culture and background when you are making an assessment of intellectual disability. That's part of the clinical guidelines. But I think in practice, it is it's used in a way, in the cases anyway, that is harmful. Most clients who come from a different culture, especially non-English speaking clients, have a much harder time succeeding in Atkins litigation, in part because the testing instruments are somewhat problematic, both on IQ and adaptive behavior. But also I think just generally that instruction to consider a person's culture, the courts have used that in a way that I think is sort of too blunt an instrument, if that makes sense. I've seen cases where the courts have said things like, okay, your expert says that you meet the diagnostic criteria, but this person immigrated from another country and they learned to speak a new language, and so I don't think they can be intellectually disabled. And that is a common misconception, right? The idea that people with intellectual disability can't achieve something like moving to a new country or learning another language. Those are just stereotypes that people have about intellectual disability. They're not part of the diagnostic criteria. So I think in some ways that instruction has been used as a weapon against people with ID claims when they come from other countries.
So what let's go back to this IQ test. I mean, what are some of the pitfalls that you try to advise attorneys on as far as the IQ tests and the administering those tests and everything like that? I think John was talking about some of the gold standards and IQ tests. What can you tell us about that?
I think the number one pitfall is that you can't take an IQ score at face value. So when someone gives an IQ test, they put down on a piece of paper somewhere, this is the score, right? And we often, I think, treat that as, that's the answer, right? That's the only thing I need to know. But there are many things, as I'm sure you know, many things that go into how should you interpret an obtained IQ score. But it's really just an estimate. An IQ score is just an estimate of your performance compared to the general population. How did you do on this test compared to the general population? And we use that to estimate what your intelligence might be. And so it's a lot squishier than you might think when you're thinking about a test that is normed and produces a number. But it really is just sort of the beginning. For me, when you're doing an investigation, the obtained IQ score is just the place to start the investigation, because you need to know so many other things. Does this person have other IQ scores? Who was the person who gave the IQ test? What incentives did they have? Those types of things all can make a big difference in how you should view the overall picture of the evidence that you ultimately collect.
And I would think that taking into consideration, looking at, depending on when they took the IQ test, you may need to have another one done. I mean, do you advise that you do one IQ test, two, three, just to get, an average score, or how does that work?
Well, you don't average the scores,
Okay.
but you do look at the overall picture if you have multiple IQ tests, and that's pretty common for our client population. It's common because you may have had IQ tests in school, or you may have had them for disability applications, or if you've been in prison before, you may have had a psychological evaluation. So there are lots of places in a person's life history where they may already have multiple IQ scores. But you don't sort of add them all up and average them. You do look at the overall picture. What else did you ask me?
No, that's fine. That was it. Just the, the IQ test, and I don't know if we talked about it, administering the test. I mean, some of the things that people need to pay attention to when they administer the test, because there could be some. I think I read somewhere in one of the papers. I think you guys were talking about how tests that are administered in prisons are not really IQ tests, or there could be some issues with it, things of that nature. Does that ring a bell? Or
Yes.
Yeah.
Well, so John talked about the gold standard IQ tests, and those are what we call tests that produce a full scale IQ score. So tests that are administered in prison settings or sometimes in school evaluations, there are lots of other kinds of tests that are sometimes even called IQ tests, or they purport to produce IQ scores. But that isn't the same as a full-scale IQ score. They're not equivalent measures. They may measure one area of what we think of as contributing to overall intelligence, but they don't produce a full-scale IQ score. And so what I tell people that means is if your client has a low score on something like that, a short form or group administered test of some kind of factor in intelligence, that may be a red flag for intellectual disability. But if your client has an average or even a high IQ score on a shorter measurement like that, it doesn't rule out intellectual disability, because what we care about for Prom 1 is a full-scale IQ score. Does that make sense?
Yeah. Thank you for clearing that up.
Okay.
So you mentioned red flag. Are there? What are some of the other red flags as far as intellectual disability that when you're speaking with attorneys across the country that you kind of advise them on?
There are lots of red flags. I don't know that I can list them all,
No,
but I mean, I think, some common ones are any type of special education, although it's pretty common in Atkins litigation to have people who are not identified in the school system, and there are a lot of reasons for that. But certainly if your client had special education services, that would be a red flag. Any type of school failure is a red flag, certainly. The work history, not having not having jobs that require very sophisticated tasks, or never obtaining a job on your own initiative, not living independently. Those are all things that would suggest really in all cases, as I said, you should be doing this investigation, but there are certainly lots of things that are common red flags that I see all the time when I'm talking with people who are considering intellectual disability claims.
It probably extends to prenatal issues,
Well, there are a whole bunch of risk factors.
Uh-huh.
There's a chart in the current manual from the AAIDD of risk factors, and they are divided into prenatal and postnatal factors. And so anything that's on the list of risk factors would also be a red flag, but I would say that with some caution, only because usually we don't know the cause of intellectual disability, and you're not required to prove the cause of your client's intellectual disability. So it's important to know what the risk factors are, but you don't have to prove the cause in order to succeed in an Atkins case.
Okay. Oh, that's good to know. Okay. So, what do you think needs to happen to kind of? I know we're this whole issue with the death penalty. Uh, you know, the landscape has changed since Atkins. Things are getting somewhat better. People with ID are still at risk. What are some of your thoughts on things that can happen to kind of get us over the finish line, so to speak? You know, Supreme Court said shouldn't put these people, shouldn't execute these people. They shouldn't be on death row. But we still have 27 states. I think 27, 26, 27 states. Of course, a few more that have the death penalty, but they just don't use it. But we still have about 26 states that still use the death penalty as a form of punishment or what have you. You know, what are your thoughts on that as far as this whole debate here?
Well, I'm not in favor of the death penalty for anyone, but I think certainly people with intellectual disabilities are much more vulnerable in the criminal justice system in myriad ways. And so they especially deserve protection from a death sentence. And I think we're doing, as I said, I think we've made some progress in establishing a rule that they should not be eligible for execution. That's a good step, but there's still a lot of work to be done in terms of having the courts understand what intellectual disability really is and what's the proper way to do an assessment of intellectual disability, and then having procedures that are fair to the defendant when you're litigating an intellectual disability claim.
Ooh. So what are of all the cases that you've worked on, that you've helped out on, do you have any that come to mind that really kind of highlight some of the stuff that we're talking about as far as why you need to protect people with ID, or you know, something that was just so crazy, so off the wall? You don't have to give any names, but that you kind of like, what? You know, anything weird like that, or any, you know?
Yes, there's a case from South Carolina that I think is a great example of both why people with intellectual disabilities should be exempt from the death penalty, and also the ways in which they're more vulnerable in general to both wrongful conviction and wrongful death sentences. And this case involves a confession, and I think that's a great example because people with intellectual disability are more susceptible to things like police pressure. They're more easily led. They're much less likely to be able to advocate for themselves, and sometimes even to remember details that would help the lawyers later litigate issues in their case effectively. So this person was convicted based on a confession that he gave after multiple days of interrogation and DNA evidence, which later turned out to be inaccurate. So, you know, I can't speculate about what might have happened had he not had an intellectual disability, but I think it's clear that his cognitive limitations contributed to his whole experience. You know, his ability to withstand interrogation and his ability to advocate for himself and to help his lawyers be advocates on his behalf were much more limited. And so I think he was wrongfully convicted. And then his death sentence was eventually overturned because he is a person with intellectual disability. But he spent more than 30 years in prison as a result of this event that he sort of got caught up in, I think, also because of his intellectual disability, because, you know, that's talked about in Atkins itself, that people with intellectual disability are more likely to be led by co-defendants and others who are more sophisticated and get themselves involved into situations that might lead to a criminal conviction.
That's interesting because I think, I don't know if you're familiar with the Jerome Bowden case, Jerome Bowden was a Columbus, Georgia. He apparently there was a crime committed back in the mid '70s. There was another younger person with him. Jerome was like, I think 20, 21. There was someone that was like 14, 15 that we believe actually committed the crime. They found a murder weapon under this younger person's home. Jerome had an IQ of 58 or 59. And I was talking with one of the attorneys that was on his appeal, and she made the comment that, you know, a confession is only half the truth.
Mm-hmm.
And it seems like, you know, that's what we continue to see when there is a confession. You know, you have to take it with a grain of salt, because you never know. I mean, like you said, they're pressured. They, you know, days of interrogation, you know, things of that nature. So I always find that kind of interesting. I always think about that when she told me that. You may have you probably answered some of this in the previous question, but I'm just going to ask it again just to see if we get a different get something else from this. What do you think are some of the top challenges attorneys face when they come to you for help, for assistance with defending their clients? What are some of the top things that you've seen, challenges that they face?
I think it's a challenge. I think one challenge is that you have to do so much work to win an Atkins case. And that's true generally in capital defense, but I think it's especially true for Atkins cases that you have to just do so much work. You really have to overprove the claim to win. It's not enough to just have an expert who is qualified and has done the work carefully and comes to court and testifies that your client has intellectual disability. It sometimes feels like that should be enough, but I don't think it really ever is. You have to do a lot to collect your client's story, and then you really have to carefully present it in a way that tells a comprehensive story. It's not enough to just say, you know, here's the evidence that shows he meets the specific criteria, but you really have to tell a narrative about your client's whole life and how it's consistent with intellectual disability and how you've collected information in a way that is consistent with the clinical consensus on intellectual disability. And you have to demonstrate repeatedly that you're correct and that everything that you're presenting is well corroborated. And that takes so much time and effort and money. And it can be a challenge to get the money and the time that you need to really do the work properly. I think that is probably one of the biggest challenges we face in this type of work.
And when you're talking about getting the money, you know, they're requesting the money from the court to do this investigation. Do we still have issues where courts do not provide the resources for more investigation or you know, testing or what have you? Do we still have issues with that?
Yeah, and I think Lindsay can tell you more about this,
Okay.
because it does impact the rates of success in Atkins litigation vary pretty widely by jurisdiction. And if you look at, you know, where are you more likely to be successful? Well, if it's a state that it's, you know, easy to get the money, or you don't face as many challenges getting funding, that's going to have a significant impact on your ability to present a claim effectively. So there are definitely places where you can vary case by case or judge by judge, but you have to get somebody to approve your request for funding in order to get the work done.
Yeah. Okay. So let me ask you this final question. What have I not asked you? What are some of the things that I may have missed in this that need to be told? as far as protecting people with ID and some of the guidelines and the things that you deal with on a day-to-day basis. What are some of the things we may have missed here in asking you about?
I think one thing that I think is important that we maybe touched on it a little bit is I often tell people that I like to think of an Atkins investigation as less of a search for their deficits and more of a search for the support. And by that I mean, in every Atkins case that I've ever had, there's been at least one or more thing that I found inconvenient, right? The client has a long work history, or the client has a successful marriage, or maybe the client went to college for a semester, or something like that, often seems at face value inconsistent with a claim of intellectual disability. And I think what matters in the investigation is finding out how much support your client needed to rely on to achieve that. And so one example I often give when I'm talking to people about this is that I was giving a lecture once about intellectual disability, and I was just sort of running through a list of stereotypes and saying things like, people with intellectual disability can drive cars, they can have bank accounts, they can get married, they can live independently in some cases, and I was just sort of ticking through my list. And this person in the audience raised her hand and asked very sincerely, if a person with intellectual disability can do all of the things that I can do, what makes them disabled? And I really was caught off guard, because that's a very good question. And the answer is they needed more support somewhere in that person's life history. If you have an intellectual disability, your life can look very much like any other person's life. But you have to have relied on, in some area, not all areas, but at least some areas, you have to have more support than other people to achieve that same life outcome. And so when we see those things in our cases, we should look very carefully at the ones that seem inconvenient, because that's where we're going to find stories of the support this person has relied on. And that's when you'll find the evidence of sort of how does it fall apart, right? When the support system is no longer present, that's often when things fall apart for our clients, and they end up involved in the crime, or their life sort of starts a downward spiral when the supports that they need are no longer available to them.
Good. I'm going to ask you one last question. What does justice look like to you in context of this discussion as far as people with intellectual disabilities and death penalty? Justice means different things to different people. What does it mean to you in this context, this broad context of ID and the death penalty?
Oh, I don't know.
And I didn't mean that to stump you. It's just something that popped in my head, because earlier we were talking about justice and how there's another side to this story about with the victims' families, and it's hard to it's got to be difficult, because they're definitely emotional, going off of that revenge factor in some cases, in a lot of cases, and how do we, and I grapple with this myself, even with this film, how do we, tell them that this is just and right when they're hurting. This is my attempt to not just tell one side, but both sides, because I think it's important, because a lot of times we don't talk about the victims' families and stuff like that. But it was just a question. It's not, I don't have an answer for it. I don't think anybody has an answer for it.
Well, it's a hard question to answer.
Right.
But I think I don't know what I would say justice means exactly, but I think we have a better chance at achieving something like justice if we sincerely examine the reasons why people become involved in a crime, and we factor things like this into not just whether they should or shouldn't receive the death penalty, but what should their punishment be overall. And if we want to do something about the circumstances that led to this event in this particular case, that would be a better step, I think, in the right direction than just sort of discarding people who've become involved in crimes.
And one last thing. I lied to you. That wasn't my last one. This will be my last question.
Okay.
Why do you do this? Why are you so passionate about this?
That's another hard question. You didn't
I know it didn't have that on the paper. I know. But I wanted like a real, organic, authentic answer. And you just seem like the type of person that would have like a real thoughtful, answer. Something.
I mean, I love my work. I think it's a privilege to be able to learn people's stories so intimately and to fight for people who need someone to fight for them. I think that my work makes a difference in my individual client's life and for his family, even if it's not successful. So I think it's worth doing for that reason, and that's partly why I do it.
Okay. Can I ask you a question?
Yeah.
I'm late to the subject, so this may be something that's already sort of understood in the subject matter. Does if someone has ID or is believed to have ID, does that play a role in their initial defense of guilt or innocent? And the capital part of that is a completely separate thing from the rest of it?
Yes. And that's actually a really important point, I think, because
Yeah, look at him.
because outside the capital context, we don't really look very carefully at all about why a person became involved in the crime they committed. And we're not doing anything to protect people with intellectual disability in the criminal context outside of capital cases. Very rarely would that be something that you can make much use of. And so I think there are lots of places in the non-capital context where we could do more to protect people with intellectual disabilities, and we should be doing that.
All right.
Okay.
Thank you very much. You're phenomenal.
This makes me very nervous.
No. Briefly talk about you and what you do and everything. Mm-hmm. Tell me a little bit about yourself as far as the what you do, here at Justice360.
I'm an attorney here, and I represent mostly people who are already facing death sentences, and most of my work, especially in more recent years, has focused primarily on representing people with intellectual disabilities. So I have a number of clients of my own that I represent as their attorney who have intellectual disability, and then I consult with a number of other people throughout the country who are handling cases involving intellectual disabilities.
Now, considering the Atkins case was like 20 plus years ago and everything, what are some of your impressions, some of your thoughts about where we are now as far as this debate of people with intellectual disability and the death penalty, and from your perspective, because you're on the ground dealing with the attorneys, you're answering questions, you're providing them support. Where do you think we are right now?
I think we've made some good progress. I think Atkins itself was a step in the right direction, and then the Supreme Court's decisions in Hall and Moore, that was some helpful progress, but I think we still have a lot of work to do. Many people, I think, have a misunderstanding about what intellectual disability is and what it means and whether they can recognize it correctly. And so it becomes a challenge. I think there are a number of people who have intellectual disabilities who are not getting the benefit of the Atkins decision, either because people handling their cases don't have all the tools they need to properly litigate them, or more commonly because the decision maker has a misunderstanding about intellectual disability and the person loses their claim based on misunderstandings or acceptance of unscientific arguments from the government or the prosecution.
Right. You know, I one of the things that reading some of the articles and papers, the one that really stood out to me was protecting people with intellectual disabilities from wrongful executions. Let's talk a little bit about that. What are some of the key things that people need to understand as far as protecting people with ID?
I think the first thing people should understand is that, in my view, every capital case is a potential Atkins case, and that it shouldn't be thought of as something that you investigate only if you think you can recognize that in talking to your client or looking at what you know about his social history to start with. But in every case, it's a possibility, and there's really no way to know if a person meets the criteria for intellectual disability until you've done a really rigorous investigation. And so the only way to find out is to do that investigation. And I wouldn't want anyone to think it's off the table from the get-go, because it's always a possibility, and it's a really important tool because, of course, people with intellectual disability, it's a categorical bar. They're not eligible for a death sentence, and so it's one of the most important pieces of our work in the capital defense community.
So you work with a lot of attorneys, not only within the state but across the country, or what have you noticed here about the state of South Carolina? I mean, we're talking about, excuse me, one of the old Confederate states. We know that a lot of executions happen in the southern states. I think Oklahoma is kind of making a play for top executor in the country right now. But what are some of your takeaways from working with attorneys here in South Carolina and across the country?
Well, I think actually South Carolina in many ways is kind of a testament to one of the things that matters a lot to me, which is educating the courts about intellectual disability. Because although you're right that it is, it's a southern state, it has an active death penalty, but we've had a lot of success here in South Carolina with Atkins claims, and I think that is in part because we were fortunate in that when Atkins was decided, we were already working on this issue, and we were able to kind of get out in front of it and set a standard for what is the best practice for litigating Atkins claims, certainly in South Carolina. And for the most part, we've had a lot of success, I would say. Not all of the cases, but certainly we've had a high rate of success, and it varies a lot from state to state. And I think some of that is based on how well you're putting the claims together, and sometimes it's based on other things like access to funding and procedural rules and those sort of things.
Okay, so let's go through some of the guidelines. I think there was something talked that mentioned the guidelines for competent representation, and what are some of the things that come to mind when you're talking to these attorneys and you're on the ground with them and they're seeking help from you, assistance, guidance, wisdom? What are some of the things that you go over with them? So some of the topics.
Well, I think one of the first things I would tell people when I'm asked to help in their case is that it's important to have as many people as possible who have prior experience with an Atkins case, because most people, when they reach out to me, it's not because they know nothing about intellectual disability. Many lawyers out there know a lot about intellectual disability and they want to do their best work, but it can be a really complex area of an investigation and preparation for a hearing, and it can be a challenge to recognize all of the things that matter in an Atkins case if you haven't had prior experience. I mean, I think it's a challenge for anyone, but it's certainly a challenge if you haven't previously handled a case involving an intellectual disability claim. And so one of the first things I would tell people is that they should get team members who've been involved in Atkins litigation or get consultants, and if they don't have that, I can try to help them get those kinds of people on board.
I mean,